Olá, todos e todas que estão conosco em mais um encontro dos Fóruns Permanentes da EMERJ. Eu sou a Desembargadora Cristina Gaulia, Diretora-Geral da Escola da Magistratura do Estado do Rio de Janeiro. E é com muita alegria, juntamente com meu colega desembargador César Felipe Cury, que é o presidente do Fórum Permanente de Métodos Adequados de Resolução de Conflitos, o anfitrião do evento de hoje, e com a juíza Eunice Bittencourt Haddad, a presidente da AMAERJ, Associação dos Magistrados do nosso Estado, que eu recepciono o professor Joshua Walker, para tratarmos do instigante, ainda controvertido e pouco compreendido tema do uso da inteligência artificial na Justiça Brasileira. O professor Joshua Walker é um dos fundadores do Codex, um laboratório multidisciplinar de pesquisas no campo da informática, voltado especificamente para o direito, da Universidade de Stanford, uma das universidades estadunidenses mais prestigiosas do mundo, onde o professor Walker atuou também como docente. Joshua Walker é advogado, especialista em propriedade industrial e também cofundador da empresa Lex Machina, a primeira empresa a conceber um software de inteligência artificial que fornece análises jurídicas para advogados traçarem estratégias na defesa dos interesses de seus clientes, buscando em nuvem as informações sobre outros litígios similares, como pensam os juízes envolvidos no julgamento, quem são os réus, comparando tendências de possíveis resultados, de possíveis valores prognósticos, danos e oportunidades de sucesso. Eu me permito uma brevíssima saudação ao professor Joshua Walker em inglês, para que ele se sinta verdadeiramente bem-vindo na nossa Escola de Formação de Magistrados do Rio de Janeiro. Professor Walker, in the name of EMERJ, the School of Judges of the State of Rio de Janeiro, I welcome you warmly and with special thanks for the time you are sparing to be able to talk to the judges of our state, to federal judges, and to lawyers and students who are with us here today. Artificial intelligence is a slippery term, as you have recently said in one of the many interviews that you gave. And I quote, "Even the top people in the world don't really know how to define it. It is a technology we must study and understand as much as we can, because it is undoubtedly the sign of the future in courts. But to understand the good and the bad and the differences between them in the many uses of this technology for lawyers and judges, we have to handle it with much care, with great care, especially in a country as Brazil, where social, educational, and economical classes are so intensively different. We are therefore eager to listen to you, and maybe you might consider coming back in a near future to EMERJ for a longer program with judges in the area you are an expert in. Thank you very much, Professor Walker." Terminada essa breve saudação ao professor Walker, eu gostaria ainda de cumprimentar meus colegas juízes de direito, Fabio Porto e Anderson Paiva, ambos atualmente juízes auxiliares da presidência do CNJ, o Conselho Nacional de Justiça, ao lado do ministro Luiz Fux. Um abraço muito afetuoso às colegas magistradas Daniela Bandeira de Freitas e Isabela Ferrari, a primeira, juíza auxiliar da presidência do TJ-RJ, ao lado do desembargador Henrique Figueira, e a segunda, juíza federal do Tribunal Federal da 2ª Região. E, por fim, last but not least, cumprimento à advogada Amanda de Lima Vieira, professora e processualista emérita da nossa Escola da Magistratura. Vamos refletir juntos, hoje, sobre o significado da inteligência artificial no exercício da jurisdição brasileira. Vamos pensar e esclarecer o que a tecnologia da informação está considerando, por exemplo, dados relevantes para o fim de compor os algoritmos que serão ferramentas usadas na resolução dos conflitos. Questões como: os algoritmos substituirão os juízes? Ou será preciso humanizar a inteligência artificial? Ou ainda, um país como o Brasil, com desigualdades tão abissais, pode ter um judiciário que se utilize da inteligência artificial? E caso positivo, quais serão os limites, as fronteiras para um judiciário que venha a ser o melhor, mais igualitário e mais sustentável pelos anos que virão? Eu passo agora a palavra ao meu querido colega César Cury e à juíza Eunice Adá para a condução do evento, me desculpando por não estar presente por motivo de grave problema de saúde na família. Obrigada a todos e todas e aproveitem o evento de hoje.
Bom, boa tarde a todos. É um prazer receber a todos aqui, principalmente os que nos assistem à distância, via internet. Estamos transmitindo ao vivo esse evento pela internet. Gostaria inicialmente de agradecer à desembargadora Tereza Cristina Gaulia, diretora-geral da Escola da Magistratura e minha querida colega, pela oportunidade de, mais uma vez, termos um evento do Fórum Permanente, que eu tenho o privilégio e a honra de presidir, nessa 74ª sessão, e agradecer mais uma vez à desembargadora Gaulia, com extensivos os agradecimentos a toda a equipe técnica que permite que esse evento possa se realizar, e faço isso em nome da Elina e da Soninha. Queria cumprimentar o professor Joshua Walker. It's a pleasure to receive you here. It's very welcome. E cumprimentar também os meus queridos amigos e colegas, a doutora Eunice Haddad, que está aqui ao meu lado, presidente da Associação dos Magistrados do Estado do Rio de Janeiro, e os meus colegas aqui presentes, Fabio Porto, Anderson Gabriel, Daniela o quê? Bandeira de Freitas e Isabela Ferrari. Sintam-se todos. E a Amanda Vieira, que está nos acompanhando à distância, pela impossibilidade de comparecer, está à distância nos acompanhando. É um prazer participar de mais esse evento, mais essa reunião, e falar de um tema extremamente relevante, extremamente oportuno, um tema que, para mim, particularmente, me é muito caro, falar de inteligência artificial e justiça, de inteligência artificial e direito. E antes de prosseguir, eu vou pedir para que a Eunice, doutora Eunice Haddad, minha querida colega, presidente da Associação dos Magistrados, faça suas primeiras saudações. Doutora Eunice.
Boa tarde a todos. Muita alegria que eu estou aqui também representando a AMAERJ, né, Associação dos Magistrados do Estado do Rio de Janeiro. Cumprimento o professor Joshua Walker. É um prazer recebê-lo aqui. Em nome de toda a magistratura do Estado do Rio, tenho muito prazer em receber o senhor. Meu colega César Cury, presidente desse fórum permanente tão importante para a EMERJ. Meus colegas aqui presentes, Fabio Porto, Daniela Bandeira, Anderson Gabriel, Isabela Ferrari e a Amanda, que nos assiste, né, remotamente, está possibilitada de comparecer. A inteligência artificial ela já está presente há muito tempo em muitas atividades, né? Já temos na medicina, nos ramos múltiplos da engenharia, na indústria do entretenimento, ciências biológicas, explorações espaciais, mas como aplicá-la no campo do direito, em especial na justiça? Esse é um grande desafio, que a desembargadora ressaltou muito bem na abertura, da necessidade de humanização de uma inteligência artificial, né? Como compatibilizar a humanização com um robô, vamos dizer assim, né? Mas é inevitável a grande importância, né, da inteligência artificial. Temos que achar esse equilíbrio da humanização com a inteligência, né? Agora, recentemente, o plenário do CNJ aprovou a criação do Banco Nacional de Precedentes, que é um grande avanço, né? A gente precisa, é uma plataforma, né, de rápido acesso que vai reunir e padronizar o conteúdo dos precedentes dos tribunais superiores, estatísticas sobre os temas, tratamento uniforme das demandas repetitivas ou de massa. E a padronização das sentenças, indicada pela inteligência artificial, por meio da identificação e localização de precedentes, é necessária para tornar a justiça mais rápida, mais transparente, mais eficiente e menos custosa. Mas é o que, repito mais uma vez, não é possível substituir magistrado por homens-máquinas, né? Não é disso que se trata. A figura do magistrado, do profissional do direito responsável por dizer o direito aplicável ao caso concreto, é intocável. A máquina abastece o magistrado, agiliza os trâmites, reúne informações dispersas, aponta acervos e equívocos. Mas a função decisória é exclusivamente dele, magistrado. Cabe a ele, ser humano, decidir, né? Sobre outro aspecto, já convivemos há bastante tempo com elementos da inteligência artificial. O avanço digital permitiu que fosse possível continuarmos trabalhando nesses 2 anos de pandemia. Nem a Justiça, nem os magistrados pararam na inesperada e trágica crise da saúde. Pelo contrário, os tribunais e a magistratura se reinventaram. E aqui a gente tem o Fabio Porto, que era o responsável aqui no TJRJ pela DGTEC, né? E ele sabe muito bem como foi essa reinvenção, né, Fábio? Estava lá com ele num período final. Os serviços continuaram sendo prestados de modo célere. As estatísticas mostram isso. O judiciário não parou. E uma matéria divulgada semana passada no jornal de grande circulação aqui no Rio mostrou que uma parceria entre a SEAP, Secretaria de Estado de Administração Penitenciária, e o Tribunal de Justiça, iniciada em abril de 2020, resultou na realização de 13 mil audiências criminais virtuais realizadas nas próprias unidades prisionais. Isso é, assim, sem inteligência artificial e tudo seria impossível, né? E esses processos acabariam em excesso de prazo, réus presos. Então, apesar da pandemia, mantivemos-nos muito ativos graças à tecnologia digital. Que venha o auxílio fundamental da tecnologia inteligente. Ela nos permitirá julgar mais e melhor. Um excelente evento a todos, que certamente contribuirá em muito para o nosso aperfeiçoamento. Muito obrigada.
Obrigado, doutora Eunice. Eu vou pedir agora para nós mudarmos a composição da mesa, né, tendo em vista aqui a necessidade de distanciamento, para que os palestrantes possam, os comentadores, os debatedores possam participar, acompanhar mais de perto e participar da exposição do doutor Joshua Walker, para que a gente possa, então, dar continuidade ao nosso evento. How long time do you need? How long time do you need? I have 3,000 people watching this on internet. That's right.
No care, no legal care.
No problem. Let's work. Daniela,
Hã? Não, senta aqui. Tá. O inglês é péssimo. Não entendo, mas não falo. Yes.
People.
Tereza, no meio do congresso é liga da escola, minha vida é assim. Aí tem que atender, criança cai no brinquedo.
Bom, pessoal, então, dando sequência ao nosso evento, eu vou conceder a palavra ao professor Joshua Walker. Eu dispenso aqui de fazer a apresentação do seu currículo, tendo em vista já tê-lo sido feito pela desembargadora Gaulia, mas reforço aqui que o professor Walker é professor da Stanford Law School, cofundador da Codex e da Lex Machina, e hoje vai falar aqui para a gente sobre a inteligência artificial e o futuro da justiça brasileira. Uma enorme responsabilidade, porque esse é um tema, como eu disse, muito oportuno, um tema extremamente relevante e oportuno, não apenas para a sociedade em geral, mas para o sistema de justiça. Há uma política pública conduzida a partir do Conselho Nacional de Justiça voltada à digitalização ou à tecnologização de todo o sistema de justiça. Isso inclui o judiciário, mas os demais órgãos de Estado e os atores que atuam no sistema de justiça para o desenvolvimento de tecnologia, de modo a tornar a justiça num nível compatível com os demais segmentos da sociedade que já contam com uma estrutura tecnológica bastante avançada. Então, sem mais delongas, eu vou passar a palavra ao professor Joshua Walker para a sua exposição. Professor, you have the...
Thank you. And can everyone hear me? I hope everyone can hear me. Otherwise, let me know. Obrigado por todos. It is such an honor to be here. And I would say, whatever difficulties you're getting here are very parallel to whatever difficulties you might have in any technology product or project you have. There's always entropy. So it's an honor to be here finally after 2 years of COVID. The night Russia invaded the Ukraine, it occurred to me that life is full of paradoxes. And a few of those paradoxes are, if you're terrified of death, you don't really live. It impairs your ability to live well. If you're so terrified, you don't want to leave your house and that kind of thing. It's an old one. Things labeled truth, second paradox, things labeled truth are least likely to be actually truth. Third, if you acknowledge universal bias in a human or in an AI, in all AIs, that acknowledgement actually serves as an inoculation to bias. Similarly, skepticism of AI often translates into efficacy of AI. So there's a direct relation between how skeptical we are while we're building, we still want to build, and how well it performs in real life. And you as magistrates, which are most of the audience, you are where, as we say in English, the rubber meets the road. That is where the life of the case and the facts and the procedure really has to get handled. And so in some ways, you are in the best position of anyone in the entire, not just judicial, but legal ecosystem to use this technology with effect. And I'll define what technology is in a bit too. The last paradox I would say is quantitative enables qualitative. So if you're terrified of technology, if you are terrified of mathematics, it can very easily start to dominate your life because it takes over areas that we aren't taking care of because we're avoiding it. And so my proposition to you, even if you hate AI, mathematical analysis, which you should be skeptical of, let's be clear, that quantitative and empirical analysis actually can empower you to do the best, most human, most creative work. And I agree with the first judge, this is not something that is coming to replace you. It's a tool, like a train or an airplane or any kind of machine. And it's something that is a force multiplier, which is absolutely necessary for you as a judicial decisor. These little paradoxes, they're not unrelated to AI. Steve Jobs is the one who pointed out the thing about death. He was fighting cancer, and he said, fear of death is actually the best tool you can have to learn how to live your life. And again, I'll get back to how that's related to AI in a moment. The organization Pravda was a Soviet news organization which propagated a lot of mistruths during the Soviet era. Social psychologists have often said that we are innately bound to be biased. Our brains are wired to be biased. But the thing they have proven, these great social psychologists in peer review and experiments, is that if we understand we're biased, that inoculates us, and it makes our worst animal instincts far less powerful. We can modulate them. And you can do the same thing with AI, which is only a reflection of our own data. You can build systems to work against that bias. You can't eliminate it. It always exists, but you can build systems that balances it out and stops the worst of these things. And lastly, quantitative enables qualitative. This empirical data can actually enable you to do extraordinary things that are on the human side and extraordinarily judicial analytic things. I'll give you 5 small examples. One, we built a system in the US that the first speaker mentioned called Lex Machina. And it was a tool that was kind of a dashboard. Think of your car, a speed limit, a speedometer, or the amount of gas you have, or if you're running a factory, not like running a court, but if you run a factory, you know what's happening. How many things are moving in, what's happening to those things, how many things are moving out, what the quality rate is, what the error rate is, how good the materials coming in are. Our judiciary had none of those, and no real consistent empirical data to make decisions about staffing, hiring, costs, fees. It was very difficult administratively on top of everything they're doing, which is exactly what every judge all over the world faces. What do you got? So one magistrate we launched the system with said, I love this because I can call a lawyer's bluff. When a lawyer comes before me and she or he says, Your Honor, I can knock out this claim, and I've done it lots of times before, he or she can test that assertion and say, well, you've never knocked out this claim in 50 cases that I see before me. What makes you think you can do it now? And so maybe you don't have to waste time on arguments that are very unlikely to be meritorious. It helps you as a magistrate to streamline the case, get certain claims resolved that there really is no controversy in. A second example, we had another federal judge. He absolutely hated patent cases. And he told this to me. I won't say who he was, but a well-known judge. He was appointed by Congress, an Article III judge, we call it. And he said he loved the system because he hated patent cases, because the system showed him how other judges who do a lot of these cases handle them, how they interpret the claims, the words in the patent. And in general, it reduced the amount of wasted time he had in these cases by about 50%. So he could focus on the cases he really cared about, which were constitutional and criminal law cases. Another example, lawyers, they can see that one judge tends to only grant one type of legal doctrine summary judgment order. So they're not going to waste time on 50 different theories and waste hundreds of thousands of dollars of clients' money on things that are likely to be a waste. They can say, this is more likely, unless there's a real reason to go a different route, they're not going to waste time on an inefficient method. And again, sometimes you have to, sometimes the interests of justice require you to fight on unusual grounds, but they can tell their client, hey, this is more likely to work than the other way. A fifth reason was when we were enacting new laws, we actually looked at, we advised the patent office in the US on other countries all over the world, South America, India, on very specific doctrines. And we said, here's what happened in India with this doctrine. That empirical data about other people and other systems and what they've done, whether it's worked or failed, saves us time and pain. We don't have to make the mistakes of others. And I think the reason I'm here is really to help you avoid making the mistakes both from the US has made in California, but also mistakes we've made in creating AIs. and legal AIs and otherwise. Most importantly, the other example I'll give you, we got a job for the Comptroller General of the United States at one point. We had this big database and a kind of analytic SWAT team, a little unit that focused on very specific analytic tasks for judges. And Congress wanted to know about a certain type of plaintiff in a certain type of claim. And what we found was, working with the Comptroller General, who's apolitical and therefore one of my favorite clients, because they're only interested in the empirical data, we found that there's no real plaintiff group that Congress was worried about. It doesn't exist. It's a phantom. But what we did find is that 95% of every software patent, just on the way we stumbled across this, 95% of the patents that are asserted in federal court are deemed invalid by an Article III judge. So the inputs we're getting are almost 95% with major errors in them. Every branch of government learned about this, as well as damage anomalies across the jurisdictions. We went to the Federal Circuit, we went to the Senate, and we went to the White House literally within a week. And not because of us, but because we enabled the data to other people. Scholars use this data. People on both sides of very harsh political divides used our data, which really took a lot of doing and convincing that we were impartial. And eventually the Supreme Court said, here is the standard for software patents. They changed the standard by seeing that this is crazy. We're wasting hundreds of millions of dollars of legal fees and judicial time, most preciously, on things that should never have been granted in the first place. So that inter-branch communication can only happen if there's empirical data. And that's maybe the best example that we can use here. And empirical data can take all forms. It doesn't have to be technology induced. It can be in Supreme Court briefs, that kind of thing. So given those examples, why are we here? What's the purpose of this conversation? And I would argue that it's to ask really fundamental questions, not just about judicial functionality in cases, but how many lives can we save by advancing legal infrastructure in Brazil? How much can we improve the economy or economic efficiency as the polity defines it, whether it's income distribution, taxation, social support, whatever you define it as? How can we improve the net system so everyone is better off and no one is unduly isolated from an economic system? Asking fundamental questions. And it might sound crazy, but I would say over the next 10 years, certainly, and maybe even over the next 5 years, why don't we try to save 100,000 lives in Brazil? Why don't we try to grow the economy or efficiency of the economy and opportunity, productivity by 10%? Again, it sounds very strange to say that. And it's very hard to prove causation between judicial economy and efficiency and a social outcome. But unless we ask those questions, we are in grave jeopardy of doing things which might seem good and actually be good for the judiciary and might help the judiciary, but at the end of the day, don't help citizens and help with us fulfill our constitutional duties wherever they may fall. So I would argue that return on investment is the first thing we need to define. And whether we use technology or whether we use innovation in other ways, to me, doesn't matter at all. I'll talk about some examples of how we've used technology, but it begins with legal analysis and it begins with studying the history. With that, I'll give you a couple stories that I think were useful to me. Then I'll talk about a few definitions, including the definition of artificial intelligence in a bit. And they're just my definitions. We can critique them. I'd love to critique them, but they're very specific. And then we'll talk about what we would like to do. We'll call it Codex Autonomica going forward and in the future, here and then globally, not just at Stanford. So when I graduated from college, we had a great kind of global spasm in Europe. Again, it was the Bosnian genocide. And there were rape camps in Croatia and in Serbia and Bosnia. There were mass killings, horrific things. And I had gone to, as a student, a very dumb student, kind of hitchhiking around the war zone, managed to not die, but fortunately, and essentially, I had been trying to get a job at the War Crimes Tribunal. And I annoyed this one lady from the State Department who had gone to my college for a career talk for a year until she gave me a job. I got one at the Rwanda Tribunal. The Rwandan genocide happened in 1994. Approximately 1 million people were massacred. It was a very low-tech massacre, but it was one of the most obtuse and complicated criminal conspiracies in history, because the real perpetrators were behind many, many layers of obscurity. And there were 10 paralegals, case managers like me, and we had a database that was being built. Many different countries participated from all over the world, and the database was being provided by one country. And our database, for all our evidence, it didn't work and wasn't what we needed in the first place. So the only way you could get evidence to prosecute or determine who the targets really should be of prosecution and investigation, the latter first, was to go through 2 million pages of microfiche. And if you're an old person like me, you remember they're essentially small photographs, and you have a crank that you turn 2 million times to find one thing, and you've got to turn it another 2 million times to find it the second time. So this system was doomed, of course. We ended up building a database from scratch with no money because the tribunal, the office of the prosecutor, had funds, but there was a delay in getting it from the UN accounts into the country, into Rwanda and Kigali. And so I had my mother sending me legal pads, things like that. So we had no resources. But we did have amazing people. And amongst this matrix of very diverse, from all over the world, diverse police experiences, diverse prosecution experiences, it was very fractious at first. But our team was led by someone named Michael Hurrigan, who was an Australian Crown prosecutor and cop to his deep in his DNA, and another team leader named Matar Diop, who was a Senegalese judge just across the Atlantic in Senegal. And they were brilliant, and they broke up the genocide essentially into 21 components. Each of those 21 components was assigned 2 investigators, typically one from Africa and one from Europe or Canada, because again, they had diverse experiences and they had different ways of communicating with people that were both valuable. And then we built a database that was isomorphic with that. And this is incredibly important. It's still the best database I think I've encountered, because the database exactly reflected the investigation, which exactly reflected what the prosecutors had to prove in front of judges. And again, we had national killings. We had we prosecuted the former prime minister of Rwanda successfully, Jean Kambanda, Dienes Bagosora, and every one of those people on the target list, the prosecutors were able to prosecute. Again, not because of us, our little database team, but it enabled people to do their jobs much better simply by organizing the data. And that's really all we're doing, even with the most advanced technology here, is we're organizing the data so you can do things in a much faster and more efficient way. And maybe we do things on top of that as well, but we'll get to that. The other thing that happened is that I had a Harvard law student visited us, and he said, "Hey, I'd love to interview you." I hadn't even gone to law school yet, because we do that again in graduate school. And I said, "What are you doing? This is a country where all of the lawyers and all of the judges were massacred, and you have this unique talent. Get to work. Do something. I can hook you up and connect you to people. Get to work. Don't just be a pure academic. Do something good, and then use that experience to inform your academic work so that it helps people." Like medical doctors or professors in medical school, they do work that helps people. They might do fundamental research too, but do some practical work as well. And what I would say with my visit and ability to be here in Brazil, I hope not to be a chattering tourist. I hope to get my hands to work and to actually help in any way that I can, maybe just teaching the mistakes that we made so you don't have to make them going forward. But that's the goal. So the other thing that happened is I went to law school, fell in love with mathematics for reasons I won't bore you with, and we started this company called Lex Machina at Stanford. We essentially had no reliable data in the United States about how many cases were in the federal system. We had no data at all about certain types of claims that were in half in state court. They didn't have a particular code. And we didn't have reliable data about the outcomes of cases at all. All of these problems were solved to some extent. And it was, it took a very large number of miracles to get there. But we've been able to essentially create algorithms that do extraction on the civil procedural docket from very, very limited data. It's not perfect. There's an infinite amount of work to do on top of it. And certainly the policies aren't perfect, but the issue of knowing how many cases and what happened in those cases is a solved problem. And it started with some poor soul, namely me, sitting in the basement of Stanford. And I was just an administrator. I'm still just a fellow and founder there, not a professor. But it starts with someone in the basement coding cases or teaching the AI how to analyze things. How to design the policy network that the AI is going to use to find things. The great thing about software, even though it is not smart, can't do the things that you do. At least it's nowhere near doing that today. It's very cheap and it's very fast. So if you can teach a piece of software, a piece of law, or a piece of administrative rule that you can use to figure out how many events of a certain type have happened in your courts, it's infinite. It doesn't cost anything else the next time it does that analysis. So those software economies of scale, they started just with patent cases. They've now spread to the entire federal docket and then state dockets in the US, which again, are radically different depending on which state you're in, completely different systems, completely different electronic systems, if they have them at all. So it starts to draw down the amount of chaos, information entropy in the system. And that information extraction is something that I think is like exactly what the CNJ is doing, thanks to some of the people at this table, is a great use case. And it teaches us history. It doesn't predict the future. We can talk about prediction in a bit, but it teaches you history and what happened so we don't have to keep wasting the same amount of work in the future. And now that work enables insurance markets. So because we know how many cases there are for even very complex commercial disputes, the insurance market has gone much, much better so people don't have the same amount of catastrophic risk they had with IP and other things. Anyway, that's a couple stories of how you can practically use this. Brazil is at the forefront of these things. And I think between the amount of judicial talent, between the interest in innovation, and I'll talk about defining that and the jeopardy of using the word innovation, but there is a strong interest in innovation and actually improving legal architectures in Brazil more than any place I've seen, including the US. You can be the best in the world at developing an advanced judicial infrastructure, in my opinion. We just have to accept the opportunity and do the work. So, as promised, I'll give a few definitions and then we'll turn it back over to the debate. I'm going to define law, engineering, legal innovation, and artificial intelligence, and then maybe access to justice if there's time. So law, in my view, is the art of regulating human behavior, state, and relationships. By state, I mean your status. Do you need to pay something or not? Are you a criminal versus a certain claim or a certain type of criminal statute or not? Relationship can be relationship to property or another person or to another legal entity. Engineering is the art of getting things done. Now, no engineer that I know on the planet will agree with me. I just made that up. But I've reviewed a lot of professional engineering definitions, and they make no sense to me whatsoever. We would call them gobbledygook. That is untranslatable, by the way. It just means untranslatable. So gobbledygook. They don't mean anything. And I'm sure I'm wrong about this as well as some other definitions, but I'm flipping the burden of proof back to the engineers to give me a better definition because the existing ones are nonsensical. But it's the art of getting things done. And they're very good at it. They leverage science, they leverage mathematics, they leverage all kinds of things. And it's something we can learn from. Legal engineering is the art of getting legal things done and things done legally. So it can be architecting an M&A deal so it's tax efficient. It can be creating a law, right? So that it does the job that it's intended to do. It can also be getting things done legally. Designing an engineering system like a transportation system or a car or other things so that it is legal, so that it abides by certain laws, or an online banking system, right? An electrical system, an electrical billing system. The other terms I would say we have are legal architecture. We can talk about legal infrastructure, like roads and bridges and dams. Legal infrastructure is something that needs to be funded as if it is something life and death, because it is. It is foundational to everything we do in the society, and we need to think about it that way and give you the budget you need to handle the matters and the complexity that you're handling. Legal subsystems. And so I was in a former life a flying car lawyer. This does not mean I was a flying lawyer that specialized in car law. We're doing things that Embraer and others doing, basically flying drones. Some of them are going to be autonomous. And we were designing the legal architecture for that as well. The reason I use the term legal subsystem, and the reason I think it's practically useful for you, as well as commercial players, is that we acknowledge that the law can be infinitely complex, and you have to separate it and then interface with other systems. So you don't have to stop what the engineers are doing, but you have to let the engineers let you build something within it. Legal innovation, I would define very specifically as a case where RP2 is greater than RP1. RP2 is return on investment times a procedure of a second type, and RP1 is the status quo, what we're doing today. So if you want to call something legal innovation, you must show a material delta, a material improvement over the existing system. And you have a burden of proof to do that. The reason I think it's so important to turn this into a formula is that in the US, in law firms in particular, there are many, many legal innovation groups. And many of them are what I would call innovation theater. They're doing things for show so that their clients stop bothering them to say, hey, improve what you're doing. You need to show that you're going to improve someone's life to do that. And the last thing I'll define, and then we'll move it on to the group, is artificial intelligence. Artificial intelligence is software that automates analysis. That's it. Software that automates analysis. Again, lots of engineers would disagree. Some would say it should include sensing and action. I don't think so for reasons we can go into. But it's just software that automates analysis. And with that, I'll flip it back to the group. Happy to talk more and talk about what we're doing in the future. But yeah, we'd love to open it up and give people time.
Oh, sure. Bem, senhor, you're sure? You finished it? Really?
All right, okay, I'll take.
We're enjoying it here.
All right.
I have to continue.
And thank you for the first judge mentioned, first of all, that she had sick family. God bless, and I hope they're feeling better right away. Second, she invited me back, but she didn't know how boring I was before she did that. So she's not going to be held to that invitation. But seriously, would love to come back. What we're doing now, so that we've seen progress in little areas, but it's not enough. When we built Lex Machina, and initially it was a purely Stanford project before it was spun out, we got access to all the judicial dockets, and it was a big fight to get that. Many judges did not want their dockets accessed for lots of reasons, but it was probably not the right decision to keep things in a silo, as it's generally not, especially not public data. So we had access to everything. And one of the things we had access to is the criminal docket for the Northern District of California, which is the federal district covering Silicon Valley, San Francisco and many areas. Judge Vaughn Walker did that, and he's just a hero for that and for many other reasons. We couldn't do the criminal docket because we didn't have the resources of the mandate to do it. And so one of the consistent things that I've found is that the projects that are most important are often the least funded. And the other reason I think Brazil is in a better place than the US and many other places, and I hope we can follow you, Brazil is better resourced, I think, for the broader society. And so you can do the fancy commercial projects, and there's an incredible innovation hubs all over Brazil, Rio, Sao Paulo, Brasilia, all over, incredible universities, but there is conscientiousness for the entire spectrum of Brazilian society, and in a way that the US probably doesn't quite have. So we couldn't do the habeas corpus dockets. Habeas corpus is rights of human, and it's where prisoners have, they're going to say their rights are getting violated. They may be getting, they're about to get killed because the gang that's down the hall is going to kill them. And then you have a lot of other habeas corpus filings that are done because prisoners have time. And for the courts, the clerks don't have time to review them all. So again, like in many places, trying to find the one case out of 100 or the 2 cases out of 1,000 or the 30 cases out of 300, where it's life and death and the court needs to intervene in 24 hours is almost impossible. So using AI to find, hey, we need to expedite this and find at least the ones we know are higher risk, let's try to find those faster, where there's a life and death risk and we can show that empirically. Let's allocate and focus judicial resources on those. We couldn't do that project because we didn't have the mandate. And so again, I think that's one of the encouraging things here. Codex Autonomica is a philosophy, it's a set of intellectual property, and it's really a global movement that is looking at 4 different things, not just the judiciary. It's looking at using types of AI for the citizen, for governmental entities, for civil entities, and for commercial entities, all 4 of them. And within the government, as we saw with Lex Machina, we're looking at the judiciary, the legislature, as well as the executive branches, every one of which have a different perspective and different needs and different user interfaces. And that's the real goal, because what we'd like to see is in 10 years, Brazil leading the world with projects big and small. Yes, there'll be grand national projects. There'll be grand state projects in Rio and Sao Paulo and the other big municipalities, but we'll also see micro-innovation from the private sector, from civil society, nonprofits and universities, all of them working together or not, depending on what they want. And let's try to save 100,000 lives. Let's try to grow the economy by a very large extent, which also saves lives, right? Because it gives people resources to build more hospitals and better schools and all those things, and better and more careful policing. So all of these things are life and death, even things like family law. And we'd love to see us targeting these grand challenges, but making progress at the atomic scale. Because going back to that late night when Russia invaded the Ukraine, the reason Russia is where it is because it doesn't have an independent judiciary. It doesn't have access to truth. It's isolated itself from it. And where's the best place to isolate truth, empirical or governmental, in the world? It's right here in your courtrooms and in the places that are training those courtrooms and the judges to be in them. It is right here in giving you more firepower, both to understand the claims and the policies, but also the crucible of our own judicial understanding. It's life and death. And thank you for having me.
Thank you, Mr. Joshua Walker. Congratulations for your speech. Very, very, very interesting. And I made very notes for me particularly. And very, very nice. Very, very interesting. Thank you one more time. And we invite you to return here to another speech as soon as possible.
I'm honored to accept. Thank you.
That's right. Bom, uma exposição excelente, fiz algumas anotações aqui extremamente pertinentes, especialmente para em relação à política que vem sendo implementada aqui no Brasil, a partir do Conselho Nacional de Justiça e aqui, especialmente também no Tribunal de Justiça do Rio de Janeiro, onde a gente tem alguns projetos na linha do que o professor Walker apresentou. Temos aqui alguns projetos em andamento no Laboratório de Inovação e Tecnologia do Tribunal, que eu tenho o privilégio de compor junto com a Daniela, está aqui ao meu lado. E um dos projetos vai bem na linha do que o professor Walker apresentou aqui, que é justamente essa... Na verdade, eu conversava ainda hoje com o presidente do tribunal sobre uma das funcionalidades, uma das estruturas algorítmicas que a gente pretende desenvolver, que é justamente fazer essa seleção imediata das classes de ações, com todas as informações passíveis de serem colhidas logo na distribuição, para que a gente possa traçar estratégias de atuação otimizada dos conflitos, identificar, mapear os conflitos, depois criar rotinas que permitam um melhor gerenciamento dos conflitos internos aqui no tribunal. A gente tem uma característica muito peculiar do Tribunal de Justiça do Rio de Janeiro, que são as demandas repetitivas, demandas de massas, demandas comerciais, que acabam pulverizadas por vários juízos, são demandas semelhantes ou demandas idênticas, que acabam sendo decididas por muitos juízes, o que torna a jurisprudência um pouco mais instável. E uma das propostas que a gente discute no Laboratório de Inovação e Tecnologia é justamente dar um tratamento mais gerencial, um tratamento de gestão, para poder fazer o agrupamento das ações que são assemelhadas, vinculando-as a um determinado juízo ou algum juízo, de modo que a gente possa ter uma jurisprudência mais estável e melhor definida, e assim emitir uma orientação sobre o direito mais efetiva, mais estável, mais previsível para a sociedade em geral e para o sistema econômico em particular. Então, fico extremamente feliz de ouvir o que o professor Walker apresenta, porque confirma que a gente está num caminho mais ou menos, né, um caminho bem ajustado aqui com o que a gente viu da exposição. Eu gostaria, então, de compartilhar aqui com os meus colegas, né, passando a fase de debates agora, e vou passar a palavra, então, para a Isabela, doutora Isabela Ferrari.
Obrigada, César. Eu queria começar agradecendo pelo convite, dizer que é um prazer estar aqui com todos vocês, com o professor, nesse espaço tão relevante, falando sobre um assunto que eu adoro. Eu vou pedir licença para quem nos ouve, eu vou passar para o inglês, vou deixar vocês com os nossos tradutores também. So, Professor, ever since I knew I would be here with you, there is so much I've been thinking about asking you. And as we have limited time, I'm addressing what is to me the most important question when we think about technology and the judiciary. But before I make this question, I wanted to give you and I wanted to give our audience a little context. As I mentioned before we started this talk, we have currently on Brazilian judiciary we have exactly 41 projects on AI within the judiciary. But none of them compares to a project that is being developed now that is called Codex. It's not your Codex, it's our Codex. What our Codex wants to do is to gather information from the courts. Today, every court in Brazil, state courts, federal courts, labor courts, electoral courts, military courts, they send information to the National Council of Justice on the lawsuits that they are dealing with. The information that is sent today is sent manually. So all the courts, they have to gather this information. And sending manually the information, what you can deliver is what we call here the cover information of the lawsuit. We call it like cover information because when you think about a paper file, it's the main information that comes within the cover of it, like the name of the parties, the name of the judge, the jurisdictional unit, and the grand topic of the lawsuit. So to deal with this difficulty, Codex is being developed, and it's an AI system that will gather this information automatically. But Codex is much more than just a tool for gathering information. Codex is an algorithm that allows us to read within the lawsuit. Codex can understand the documents that are within the lawsuit. This means, basically, that we're creating the infrastructure to make a shift in the way we address the lawsuits. We will be able, once this infrastructure is ready, and the idea is that it is ready as of the middle of this year, from July on, to make a shift, if we want to an algorithmic logic. And for those who are listening to us and that might not know what is algorithmic logic, it is basically when you face a problem, and instead of deciding individually the problem that you have, you take this grand problem and then you split it in small problems, and then you think and you model a solution for those small problems, and then you start using algorithms to decide those small problems. So my point is, I'm not saying that this will happen, but once Codex is ready, we'll have the infrastructure we need to do basically everything we want with AI in the judiciary. We could use algorithms to draft decisions, and we could as well use algorithms to decide instead of judges. And my question to you is, in view of that, and in view of situations that start and that we might compare, and that at some point they might seem like weird, but when we think a little more, they don't. For example, we were talking before we started this talk here that we can use robot mediators or automated mediators to make this activity that today human mediators do. And we can accept this. We could go one step further and use algorithms to rule decisions that would be adopted if the parties decide not to appeal. It doesn't seem absurd because parties could agree on that. They could make a private contract if we're talking about proprietarian rights. Or we could have a robot judge to decide cases that are extremely repetitive and that are objective. They do not demand a lot. And this could including be a way to deal with bias. I mean, because you could find before that there is bias statistically, and then you could use models to fight this bias. So my question to you is, what do you see as a limit to using AI in the judiciary? What is the point where you think that we shouldn't use that like anyhow?
You want to take that? I'd love to hear from everybody on that, actually, if you'd be open to it. Those are great questions. I want to talk about algorithmic logic first. So this is purely a technical issue, but it does go to fundamental elements in philosophy of law and how it gets created. There is a massive debate in the computer science community that's been going on for 80 years at least about logic versus statistics, or even natural language, grammarian review of words versus statistical view of words. If you go into a computer science department, they're like separate. They don't talk to each other. The statistics people, they're tired of logic. Logic was what we started AI with a long time ago. And statistical methods it's a different skill set as well. And we had that issue at Stanford quite a bit. In my view, there's no real fight between logic and statistics. We use statistics to reveal information which made logic possible. And it enabled the judges to do analogic reasoning to map things that were neither logic nor statistical, right? You actually can do things that enable a third or fourth type of reasoning to do that. So I don't think there's a conflict between logic and statistics. Both are useful, and one enables the former. With what I would say is, if you have every case in the world and you have every document in the world, you have just begun. I think it's like getting a black belt in Brazilian Jiu-Jitsu or something like that. The belt turns white when you're really good, and you start all over again in the Dan system. You've got to redo it. So wonderful. I think the burden of proof is on us to say, hey, we can actually do this and it's good. The burden of proof is on technology to do that. But if you do that, that's amazing. And judges will be free to do more important, take really tricky cases that can't be resolved statistically. Maybe they're completely new social issues. Those are going to pop up. You also have to figure out, what's the relation between my judicial ecosystem and commerce and contracts, all this dark matter that's out there. It's not in a vacuum. It's just the tip of the iceberg. So the data about how we manage our societies efficiently and justly, it's an infinitely hard problem. If we can resolve a lot of things quickly with AI, I think that's amazing. Burden of proof is on us. Let's start with organizing data, getting basic information really, really accurate, because everything is entropy when you're working with those kinds of data systems, from data formatting to how people express themselves to the legal meaning of terms. But that's wonderful. And the last thing I'll say that before addressing your real question is, how far is the AI going to go? We don't know. We have never had something that was quote unquote intelligent like we are, that we've created in this way. If you discount dolphins and dogs and things like that, we've never created something that is also an intelligence. So we can't possibly know how far it's going to go. We do know that intelligence is compounding, and you've got to dive into it if you don't want to be the victim of it, right? You need a clerk, or you need to have yourself some access to some of these things, because it's going to help you do your basic job. As with a black hole, you don't necessarily know right now how good artificial intelligence is going to be. My friends that are deep into this, people like Andrew Ng, who's and others, say it's a little bit like arguing about overpopulation on Mars. We've got to get there first. It's still a long way to get there. In my view, I don't think AI should be doing judicial decision making. Maybe that's just my bias. Maybe I'm too human, right? But I think the system is created for humans. My definition of return on investment is, does it help a human, a civilian, or the people that is supposed to be representing humans? Does it help a citizen? And so, because humans have that vested interest, having a human mediator to cross-check the machine, I think is a great thing. But I think this is a good debate that you should have. And it is not for me to say. It is for a legislature to pass a law to determine, hey, this is the right area, and the judges have to tell them the right way to do it using data. And again, just with patent law, which is not the most important area of law. It's important. There's hundreds of billions of dollars just in the US on this. It helps the economy move efficiently, but that's just one area. It used to be that with patent law in the US, it was like the sides were arguing about rearranging the furniture in the dark. The living room was black. We had no idea what this couch was, and people were arguing about where to move the chairs. The lights went on, and now we can say, oh, maybe the dog bowl shouldn't be on the easy chair, and maybe we should move this over here. You can argue about real things. This is a policy issue that I think goes to the citizens and the legislature. And it can't be a star chamber. It has to be done by that. But by creating that possibility, we can empower citizens to make good choices about it. Again, informed by the judges. Did I answer your question, or happy that we can keep going? Yeah.
Bom, extremamente interessante essa pergunta feita pela Isabela a respeito dos limites da utilização da inteligência artificial, principalmente no sistema judiciário, né? Acho que é o grande desafio que nós temos para aplicar inteligência e automatização de procedimentos, justamente pela falta da participação humana naquilo que que se torna automatizada. E essa relação entre a lógica, a inteligência artificial e o comportamento humano me parece que seja a questão fundamental, a questão central pela linguagem matemática da inteligência artificial, da linguagem algorítmica, uma linguagem formal, sintática, e a que a gente vai acoplar os conteúdos semânticos próprios de uma linguagem especial do direito. Só que a linguagem do direito não é uma linguagem, ela é uma linguagem abstrata, né? O direito é uma linguagem abstrata. Ele só se torna concreta com o comportamento humano. E o comportamento humano é o que há de mais complexo, e matematizar isso, transformar isso em linguagem algorítmica, talvez seja o grande desafio da inteligência artificial no judiciário. Eu vou passar a palavra agora para o Anderson para fazer alguma sua participação.
Então, boa tarde a todos. Queria saudar todos os presentes em nome do desembargador César. É uma honra e alegria estar aqui nesse evento. Estou extasiado aqui em ouvir o professor Joshua, uma grande satisfação. Fiquei refletindo ao longo de todo esse tempo, inclusive com a fala da Isabela, e vou fazer aqui minha indagação e minha reflexão, trazendo um pouco à baila as questões que o professor expôs e que foram enfrentadas no seu livro, falando dessa questão da guerra. E por que eu estou trazendo esse assunto à baila? Porque, como a Isabela colocou, há no Brasil uma resistência especial à tecnologia no âmbito da justiça criminal. Há uma aceitação muito maior com relação à justiça civil como um todo, mas no âmbito criminal a resistência é muito grande. Não só ao uso de inteligência artificial, como mesmo à realização de audiências virtuais. No Brasil nós temos chamadas audiências de custódia, custodial hearings, em que há muitas pessoas rejeitando, embora o nosso Conselho Nacional de Justiça tenha admitido, dentro desse contexto pandêmico, quando não for possível de forma presencial, em 24 horas, mas me parece que isso tudo perpassa um debate muito antigo na filosofia, envolvendo o racionalismo, o empirismo, de certa forma o idealismo e o pragmatismo. Queria falar um pouco sobre o nosso processo penal hoje em dia, e de certa forma penso que nós temos vivenciado uma certa concepção até nefelibata. Qual é a nossa realidade? Nós temos um Código de Processo Penal de 1941. Né? Pensem no mundo de 1941, a realidade era completamente diferente. Nem pensar em computadores em 1941. E o Brasil passou por muita coisa depois disso. Nós temos uma explosão de casos enorme. O professor George Fisher, de Stanford, até menciona que o plea bargaining nos Estados Unidos surgiu justamente no âmbito de uma explosão de casos, na época da lei seca. Né? E nós vivemos algo semelhante no Brasil hoje em dia, uma explosão de casos. Vivemos também, e penso que é um fenômeno contemporâneo não só do Brasil, mas uma multiplicação de tipos penais, uma multiplicação de possibilidades de crime. Recentemente vi que não tomar a vacina ou algo relacionado ao contexto de vacinação ou não exibir o certificado de vacina tinha sido aprovado na Câmara como mais um tipo penal. A cada ano nós temos um sem número de tipos penais surgindo e praticamente nenhum desaparecendo. Por óbvio, isso leva a um aumento do número de processos criminais também. Diante de todo esse cenário de um enorme número de casos criminais, o fato é que nós temos um percentual de prescrição muito grande. Diria que a cada 10 penais, talvez 10 casos criminais, 4 não cheguem ao final, à aprovação de uma sentença. A minha pergunta dentro até do que a Isabela colocou, o professor acha que o processo criminal, o processo penal, seria um dos limites ao uso de inteligência artificial? Já vou dizer que eu penso que não, até à luz do que o professor comentou no âmbito da guerra. E trago até alguns dos desafios contemporâneos à sociedade. Esse mundo 4.0 que vivemos, esse dinamismo contemporâneo, mais do que isso, cada vez mais visualizamos os cybercrimes, visualizamos a dark web e visualizamos as criptomoedas, que demandam um número de dados, de análise, de transações cada vez maior. Tem um projeto, se não me engano, Gaulia, da União Europeia, que inclusive está trabalhando nisso, na capacitação de diversos países, inclusive do Brasil, nesse contexto de dark web, cybercrimes e criptoativos, lavagem de dinheiro envolvendo criptoativos, e me parece que seria impensável achar que a capacidade humana hoje vai dar conta desses desafios. Então, minha pergunta é, o professor acha que o processo criminal, que os casos criminais seriam um dos limites à racionalidade humana? Sei que também nos Estados Unidos há muitos questionamentos, inclusive o aplicativo Compass foi muito criticado, e aqui já faço a minha ressalva. Não vejo o uso de inteligência artificial no âmbito do processo penal como no caso do Compass. Acho que transparência é fundamental, mas acho sim que pode ser uma ferramenta importante no combate ao crime, desde que, como o professor colocou, seja uma ferramenta posta à disposição do humano, e sempre com transparência para que se saiba quais são os critérios empregados para se chegar àquela conclusão.
Yeah. Those are, again, great questions that we wrote. It'll take only about, I don't know, a long time to resolve, probably more time than we have today. But to ask the question is the most difficult, most important thing. Before I forget, if I haven't been clear, if there's other things, there's a book called On Legal AI. It's written in Brazilian Portuguese that is out there, and it addresses some of these issues. When you're building an automated car, if you terrify the passengers, even if they're completely safe, it is not a good car. And so even though you want to focus on how long does it take, what does it cost to get there, and the cost of the parts and the safety elements of it, you can't terrify your users. If you terrify your users, that's considered a ding on your, the efficacy of your product. And any product, and I've been one of the too many things I've done has been a chief product officer. When you're doing this, your client's semantic experience of your software is enormously important. So for us, that a federal judge was using our piece of software, we had a CEO of a top 5 global company, partners at law firms regularly used it themselves, right? Not the first year, but themselves. You want people to want to use this. And if people are terrified of it, you have to be really careful. Communication is part of the system. Even if we solve the technical issues of who did what when and what category they're classified in the civil criminal law construct, it's important. So the terror of people, how they feel is important, even though it's a different type of data. One of the, going back to another issue that Isabella mentioned, once we get the data down to look at the data and see what happens, you can compare it to other systems. And you can't necessarily, everyone wants to compare themselves to Singapore or Finland or Albania, or Luxembourg, right? Let's compare our criminal law outputs to Luxembourg. Luxembourg is a very different nation state than the US or Brazil. So you have to understand the limits of data, but you can certainly compare it. And it may be that we can learn, the US can learn from Brazil and Brazil can learn from the US. We can't be the laboratory of the nation states if we don't have the data. So once you get that data collected, you can compare it more rationally to others and come up with ideas. The second thing that we can do with this, again, before we get to the predictive side, is we can do predictive modeling of statutes before they're passed. So you may not know something, but you can potentially predict, saying, hey, we've seen this transfer issue or we've seen this criminal law issue happen a lot, and the judges really seem to think that this is likely to happen. So their semantic view corresponds to statistical empirical data. You can find problems with things before they're passed. And that's revolutionary for people. And it's not going to be the senators, the congresswomen, or it's going to be their staff. It's going to be the nerd on the staff of the famous senator, and she or he is going to take the data and say, okay, I see some things, and you can testify. People like yourselves can go in and say, hey, if we change the law this way with the vaccine certificate, we may see this effect, and it may swamp the magistrates, it may swamp the courts. We've seen this, what France did, we've seen what the US did, and maybe we should tweak the law a little bit. So if you testify, you can do this before the problem happens. And that's just revolutionary, to use data to craft the statute better. Using statistics and those kinds of data are full of pitfalls, as we know. But you have to use data, at least for civil cases, because they're automatically creating briefs. They're automatically creating complaints. So the lawyers are using this to become more efficient. The judges have to use their own AI to buffer AI. Same with crypto criminals, right? They're using all kinds of automated analysis with no holds barred. You need to use AI as a tool so we don't get left behind. A bad example of the use of statistics and AI modeling is when COVID hit, the A levels in Britain had to be canceled, which is the most important exam for a high school student. So they gave marks to people based on the expectation of how they would do. That, I would argue, is a terrible use of AI. It was efficient, but if you went to a poor school, you couldn't overcome the statistical disadvantage you have. Like, at least give people a chance. At least give people hope. Don't say you're doomed, so we're going to forget about you. You're getting a B-. Like, that is a terrible message to send to a teenager. And they reversed it, right? Because there was a big outcry. So even more so with criminal law issues, you know, and recidivism. They're using lots of predictive models on recidivism, which we have to use to some extent, but we can be skeptical of those models. And that skepticism is going to help us further justice. Same thing with you know, predicting guilt is a potentially deadly use of AI. That's what people do, right? Not only do we have prejudices about who committed what crime, but the statistics might say you're from this place. If an unusual thing happened, the criminal law has to be able to handle that issue. I would again argue that if we're using AI in these other areas, frees you up to focus on more criminal cases. That's great. How and where to use it in criminal is complicated. I think we have to use it for information extraction, but not for judgments necessarily, at least.
Ok, very nice. Muito boa a sua...
Só para dizer que eu comungo integralmente da posição do professor e acho que esse é o caminho. Eu acho que é possível o uso de inteligência artificial, mas basicamente para se extrair efetivamente informações dentro desse contexto de quantos dados é possível, por exemplo, no crime de lavagem envolvendo criptoativos, criptomoedas, por exemplo, mas não para predizer comportamentos ou, como era o caso do Compass, né? Qual seria o risco ou não de alguém voltar a delinquir. Então, acho que o caminho seria esse.
É ótimo. Essa discussão é extremamente interessante, porque ela tem uma questão fundamental, que é a capacidade de tornar generalizável a conduta humana. Na medida em que a lei é um processo de abstração e generalização de comportamentos, quer dizer, de um certo modo, a lei convencional, a lei tradicional faz isso, né? Ela extrai um dado da realidade, generaliza e torna abstrato, para que cubra uma certa gama de comportamentos assemelhados, né? Principalmente isso vale muito para o direito penal, porque não se tem crime se não tiver uma lei anterior. Mas a lei é genérica e abstrata, ela não é feita individualmente. Quem vai individualizar é o juiz. Para transformar o comportamento humano numa regra matematizada, automatizada, me parece absolutamente impossível. Porque a lei normal, a lei tradicional, ela já não tem o conteúdo fático, fenomenológico, real do que aconteceu. Isso vai ser depurado durante o processo de conhecimento, o processo judicial. E vai ser traduzido numa sentença. Me parece que a inteligência artificial não teria como fazer isso, porque ela trabalha com padrões de comportamento. Não se pode pegar um padrão, estabelecer um padrão geral de comportamento para todas as pessoas, principalmente na área criminal. Mas entendo que aquilo que pode ser matematizável, quantificado, né? Aquela relação que o professor Joshua falou no início, entre a qualidade e a quantidade, né? Quer dizer, tudo que puder ser quantificado, matematizado, é passível de ser representado artificialmente, por inteligência artificial. Eu concordo também, quero deixar aqui bem claro que eu concordo com ambas as considerações aí do Anderson e do professor Joshua Walker. Agora, eu tenho uma questão aqui da Flávia Hoskin, que é sobre a compatibilidade entre a inteligência artificial e a inteligência humana para a construção de uma cultura de paz. How the AI can contribute to a culture of peace together with the human intelligence.
I think this is really vital. One of the things we talked about, I believe, with some of the Brazil Codex people a couple of years ago was something called Citizens AI. And Citizens AI, the concept is, based here and in Sao Paulo, the concept is the beauty of software is that it has economies of scale. So it's very, very expensive to build, fixed cost, but each additional use of it costs zero or almost zero. And the marginal cost for additional users is also zero. And usually you can adapt that algorithm or that machine, that platform, to a different use case. And it's not like you have to rebuild the whole thing. You've got to adapt it. And that actually happened with the information extraction we did for the civil docket in the US. But let's flip it on its head for a second. If you can build an AI for once, and it's expensive, but it can be used by everybody you can make copies of it infinitely. Why not do that for citizens? Why not have, I don't have access to justice, and I've been fairly fortunate in my life. I'm thankful for that, which is another reason I didn't try to define access to justice. It's so hard to define. If you have an agent that is kind of looking out for you and saying, hey, you may be aware that there are these pitfalls, and they can be things like it's illegal to turn left on this street, or there's gangs here, and here's what happens to a lot of people in your neighborhood. In addition to the crime, it may be the criminal stuff that's going on. Understanding that, if you smoke a pack of cigarettes in the United Kingdom, there are very graphic pictures on that pack of cigarettes about lung disease and people with holes in their throat. Yes. So again, having an AI to say, and not just problems, but more importantly, if you want to go to school, if you want to be healthy, here are some options for you, at least something that could help them interact with the system a little bit better. And it's something that could help the judiciary too. If they've got, if everything from citizenship documents together, right? We watched the CNJ video of not just people in the metros, but people in the Amazon and Amazonia trying to prove their citizenship, right? Where they didn't have documentation. I would love to have an AI that person could have access to, make a phone call, right? And say, okay, you might need these documents. You could privilege the information, you could make it somewhat protected, right? Except in extreme cases, but someone that could be almost an advocate, and you could replicate it 220 million times at zero marginal cost. So again, the most important projects are the least funded, but that's something that I would love to see, is an AI that is almost the agent of an individual citizen, that again could help interface with the court. They're not doing things, they're not empowered, but they can at least help say, hey, you need these documents if you're going in front of this procedure.
Respondido? Tá certo. Fábio, você quer fazer alguma pergunta?
Presidente? Não, presidente, eu vou dispensar, porque nós estamos com o horário apertado. E ladies first, a gente tem a doutora Amanda, que eu queria ouvir,
Amanda.
E a doutora Daniela antes. Então, se sobrar um tempinho, eu falo, senão...
Tá certo. Daniela, você quer falar alguma coisa?
Eu queria fazer um breve comentário, se for possível.
Por favor.
Eu vou fazer um comentário bem objetivo e de ordem prática. O primeiro é com relação à ética dos dados. Eu vejo que a discussão toda perpassa pela escolha dos dados. Não há inteligência artificial sem dados, sem estruturação de dados. E essa estruturação passa por escolhas. Mesmo que, como a Isabela mencionou aqui, mesmo que se utilize a inteligência artificial para estruturar os dados e para fazer essas escolhas, é necessário que, antes de montar este sistema que vai estruturar os dados, são feitas outras escolhas precedentes ou prévias. E essa ética na escolha dos dados é uma grande questão para o judiciário, porque o judiciário trabalha com dados muito sensíveis, dados relacionados, por exemplo, à violência doméstica, violência contra mulheres, violência contra menores, dados criminais. Então, nós trabalhamos com dados muito sensíveis. Então, a grande preocupação, penso eu, no âmbito do Poder Judiciário brasileiro hoje, e isso foi até tema e conteúdo de uma normativa, de uma norma do Conselho Nacional de Justiça, que trata sobre essa questão da ética da inteligência artificial e sobre os desafios do uso da inteligência artificial no âmbito da ética. Então, eu queria que o professor explicasse um pouco melhor qual a sua opinião, qual a sua posição em relação, por exemplo, à necessidade de um comitê de supervisão, por exemplo, da escolha de dados para a construção de um sistema com uso de IA, e também na possibilidade de se pensar no âmbito do Poder Judiciário, não só no Brasil, mas a nível mundial, internacional, da criação de bancos adversos, de eventos, de desvios relacionados à escolha de dados com uso de inteligência artificial. Essa é a primeira pergunta. E a segunda pergunta, eu sou uma entusiasta do robô juiz, ao contrário da nossa amiga aqui, colega Eunice. Acho que o juiz ele tem que ser vocacionado para os leading cases ou para os hard cases, e para os pequenos casos ou casos repetitivos, o robô ou o uso da inteligência artificial se prestará a esse papel, como foi dito aqui pelo professor. Só que isso demanda uma evolução do próprio uso da inteligência artificial hoje. Quem estuda isso sabe que as redes neurais humanas não são semelhantes às redes neurais com uso de inteligência artificial. Então, é necessário que haja que a inteligência artificial se desenvolva no âmbito do Poder Judiciário com essa visão do lado humano, do juiz humano, que a inteligência artificial possa se aproximar, mesmo nos pequenos casos ou nos casos repetitivos, das redes neurais humanas. Então, que também queria ouvir um pouco o professor a respeito desses dois temas. Muito obrigada.
Obrigado. Those two little questions could take many months or years to fully address properly. So I'll touch on them a little bit. There's a couple issues. One problem we have with judicial data is it is full of, again, even if it's not under seal, a lot of it's still private or at least dangerous when exposed. So in the US, we have a doctrine called fair use, which says, hey, if you have a Betamax or a cassette tape, you can give it to your friend and they can borrow it. And so we had this doctrine, and then all of a sudden the internet happened, and you could share it with your closest 2 million friends. And so then the copyright had no value anymore because you could get it freely. So the Napster decision said, just because of the technological scale, we have to change the law or have to adjust our doctrine, because otherwise the fundamental statute and right to property doesn't exist. Same with data. You know, in addition to places where we've revealed social security numbers accidentally in filings, happens all the time, right? There's tons of cases where a litigant or an attorney might accidentally put something in that was supposed to be under seal or redacted. Even if you don't, you might have a divorce case that might reveal that this person has 5 million reals in a bank account, and it's this bank account. Even if you don't have the number, you're making that person a target for criminals, right? In domestic violence, you might be revealing information. Again, some of it should all be under seal, but even the filing of it could be dangerous when that stuff's available. If you look, there are so many predators all over the world that go to national sites, and they start calling you the instant they see a filing. So California, I had a friend who was filing, he had a disabled child. The moment he filed these documents, which were public for some reason in California, he started getting scammers calling him. They targeted him because he knew he was in a crisis and he was vulnerable. And so you have to think about these greater policy issues by making the data available. You have to think about anonymity. I will say, look at Europe, look at the United States, as well as even the PRC, People's Republic of China, and see what they're doing. Avoid the mistakes we've made. I love Silicon Valley. It's such a place where you can go down the street and everyone wants to change the world. I also hate certain things about it. And one of the things I hate is there's a presumption that your data is someone else's. So data rights and data control have to be fundamental issues. It goes to the citizen, it goes to the court, it goes to the public policy issues. And you have to carefully and with a diverse panel, think about them and challenge our assumptions and figure out what's going to happen. Let's predict what's going to happen because it happened in France, it happened in the US. Let's avoid those problems. And I think you can, I love how you put with the judge robot thing. I think that's exactly right.
Ok. Bom, não sei se a Amanda vai querer fazer alguma pergunta. Vai querer fazer alguma pergunta, Amanda?
Se puder, rapidinho, que a Daniela meio que já caminhou aí na direção que eu gostaria.
Está dizendo aqui que a Daniela já teria falado. Eu não consigo te ouvir aqui.
Não está me ouvindo?
Melhorou. Melhorou? Melhorou?
Será que a gente consegue colocar o som aqui de quem está nos assistindo, que tá acompanhando à distância? Bom, enquanto isso, então, Fábio, você quer fazer alguma consideração?
Só me informem quando tiver ok. I will ask you. So sorry, I will speak Portuguese for our public. Ok? Já foi? Amanda, tenta dar uma palavrinha aí para ver se a gente escuta.
Consegue, Amanda?
Doutora
Oi?
Amanda.
Agora sim, pode falar.
Então, boa tarde a todos. Eu vou fazer uma pergunta muito rápida, porque a Daniela já antecipou um pouco o que eu gostaria de perguntar. A gente está afinada aí na questão do pensamento. E I'd like to ask you, Professor, who can control? Who is interested in some results, in some particular results, or some particular data that is inputted in artificial intelligence system? Or in other words, who plays the impartial role in this scenario?
Okay. That's another great question, and it goes back to Judge Daniela's comment as well. We, the user, and ultimately the entire set of users, in my opinion. So when we built Lex Machina, one of the things we did is, and again, this is just people sitting in basements and trying to collaborate, so it's not perfect, but it was illustrative here. It was designed so that you could see the map, and then you could zoom in. We assumed all data were false until proven otherwise, just like we assume bias. So the user could zoom in and look at, say, okay, here's the grand statistics, and then you could zoom in on a district and a unit and a case, and here is the signed document by the judge and the docket showing it was the last docket. We assumed everything was false until proven otherwise. And so what happened was, no matter how arrogant you are, by opening things up to the world, all the clerks, all the judges, all the academics who have a lot more time, usually, all the students, they can see it and they will find the errors. And so while I would say there's benefits and pitfalls to open source versus closed source or cathedral model of software, one of the advantages of making the data open is that, to many eyes, all errors are shallow. So as they say, it will help you find it. So my answer is it's the user or the entire set of users that are going to determine if the data is correct. And you assume it's wrong, right? You assume the algorithm determination is wrong or the human determination tag is wrong. One other comment to Judge Daniela's, Dr. Daniela's comment, maybe a citizen's AI is one of the things that can help guard the individual's rights, right? Because she or he may not have an advocate. They may be too busy to go to court and say, hey, don't take my data for this purpose, to take it for this other purpose. But it can streamline some of that protection activity, at least potentially. But I think it's the user that gets to decide, and we assume it's wrong until hopefully it's proven otherwise.
Thanks so much. It was a huge pleasure to watch your speech.
Ok. Mr. Fabio.
Hi, Professor. I would like to thank you for coming, to thank you for sharing with us all the knowledge. I appreciate so much. So I ask apologize to speak Portuguese now. Bom, presidente, eu gostaria de agradecer a Vossa Excelência a composição dessa brilhante mesa, né? A começar pelo meu amigo Dr. Anderson, estou vendo não, ladies first, mas na ordem da mesa, a doutora Isabela, a doutora Daniela, a doutora Amanda virtualmente. Eu acho que todas as perguntas foram feitas de forma extremamente salutar. Eu teria aqui, professor, umas 40 perguntas de tópicos que eu anotei. Não temos tempo, mas vamos ter outro encontro. Então, prometo que no próximo encontro eu farei várias perguntas, porque temos um horário aí, estamos em cima. Eu deixarei, então, minhas 40 perguntas para segunda-feira, quando teremos um outro encontro, para tirar com o senhor e agradecer aí, presidente, a possibilidade de compor essa brilhante mesa com tão ilustres colegas e tão renomados juristas aqui na mesa. Muito obrigado.
Eu que agradeço, Fábio. Obrigado a você, obrigado ao Anderson por terem proporcionado esse encontro. Bom, gente, então a gente já está encaminhando para o final, não é isso? Bom, então eu gostaria de agradecer mais uma vez ao professor Joshua Walker por ter participado desse evento, compartilhado seu conhecimento, seu tempo com a gente aqui, participado desse debate extremamente profícuo. Gostaria também de agradecer a presença dos que compõem essa mesa, porque tornaram esse evento magnífico, uma qualidade extraordinária. Doutora Eunice, doutora Daniela, doutora Isabela Ferrari e os meus queridos amigos Anderson e Fábio. O evento foi realmente um evento muito proveitoso. Queria agradecer também a todas as pessoas, mais de 300 pessoas nos acompanhando aqui ao longo desse tempo todo, que é algo extremamente significativo. Estamos aqui ainda com restrições em razão da pandemia, mas o assunto é extremamente interessante e a qualidade do expositor e dos debatedores é que permitiu a presença tão expressiva das pessoas que nos acompanham na internet, por internet, às quais eu também agradeço pela audiência. Então, eu gostaria aqui de pedir para que o Fábio fizesse a entrega do certificado, uma lembrança, uma memória, ao professor Joshua Walker pela sua brilhante conferência.
Obrigado.
Eu tenho aqui, queria agradecer a Amanda também, que nos acompanha de casa, que participou dessa mesa virtualmente, e entregá-lo o certificado, o que será feito mais tarde. Bom, eu gostaria de agradecer, cumprimentar e parabenizar pela sua participação, doutora Isabela Ferrari. Vou passar aqui também agora as mãos da minha querida amiga e colega, doutora Daniela. Obrigado. Anderson, muito obrigado pela sua participação mais uma vez, obrigado por ter proporcionado este evento. Professor Joshua, please, pass to Dr. Fabio. Thank you. Eunice, está aqui. Obrigado, querida. Nossa presidente da associação. E eu também acabo recebendo das mãos virtuais da doutora Cristina Gaulia. Muito obrigado pelo meu certificado. Bom, estamos encaminhando aqui para o final. Gostaria mais uma vez, renovando os agradecimentos à doutora Cristina Gaulia, desembargadora Gaulia, querida amiga, colega e diretora-geral da Escola da Magistratura, que proporcionou as condições necessárias para a gente fazer mais esse evento, 74ª reunião do Fórum Permanente de mediação, que eu tenho a honra de presidir. E agradecer a todos os participantes, a mesa, o professor Joshua mais uma vez, a todos que participaram virtualmente, os membros da mesa, a Amanda na mesa virtual, a equipe técnica da Escola da Magistratura, meu pessoal lá do NUPEMEC também, que também sempre contribui com essa participação, e até uma próxima oportunidade. Meu boa noite a todos. Declaro encerrada a sessão.